Hi, welcome to this PowerPoint. I am Miss Joanne. This PowerPoint focuses on companies' insolvency. For more details of the information, you can always refer to the textbook, Unit 3, page 9 to 12. This slide talks about the laws governing bankruptcy when it's referring to individuals. When it comes to companies, we call them insolvency. In this particular slide, you can tell the difference between individuals and companies in terms of the laws governing bankruptcy, which is administered by Australian Financial Security Authority. Whereas for the companies, which is the focus of Unit 3 and the focus of Year 12, insolvency of the company is governed by Corporations Act 2001 and administered by Australian Securities and Investment Commission. As the focus of Year 12 is in terms of company, today this PowerPoint will solely focus on insolvency in companies as defined by Corporations Act 2001. According to Corporations Act 2001, solvency is defined as the ability to pay all debts as and when they become due and payable. A person or an organization who is not solvent is considered insolvent. However, Corporations Act 2001 does not provide any guidance on how to assess whether debts can be paid by the corporation. In this slide, you will see what is considered the symptoms of insolvency. In a case called ASIC versus Plymin in 2003, Justice Mandy has identified the following symptoms as company possible of being insolvent. There are 14 symptoms being listed here. It can start from number 1, continuing losses by the company. Number 2, having a current ratio below 1. Number 3, overdue Commonwealth and state taxes. Number 4, having a poor relationship with the company's bank in terms of inability to borrow additional money from the bank. Number 5, inability to borrow money from other financial institutions. Number 6, inability to raise additional share capital. Number 7, suppliers asking the company to pay on cash on delivery terms. Number 8, taking a lot of time in paying the creditors. Number 9, when the companies are issuing post-dated checks. Number 10, checks that is being issued by the company are dishonored. Number 11, making special repayments agreement with creditors. Number 12, when we are paying the creditors by installments. Number 13, having letters demanding payment of debts. And number 14, not being able to produce information about a company's recent performance. So here there are 14 symptoms that may indicate a company being insolvent. So, what do insolvent companies do? They cannot declare bankruptcy as individuals do. What can they do? They can choose forms of insolvency. As stated here, there are 3 forms of insolvency. The first form is called voluntary administration. This happens when the directors of the company or a secure creditor who has not been paid appoint an external administrator known as voluntary administrator, which most likely an accountant. What do the administrator do is he or she will take over the running of the company's affair. During the process, the voluntary administrator will assess the health of the company, report to the creditors and directors, and recommend if the company should be liquidated or returned to the control of the directors. Next, when this thing happens, when the affairs of the company is handed over to voluntary administration, this gives company time for its future to be worked out. Creditors cannot take action to recover amounts owing to them without court approval or without the approval of the administrator. This stops the claim of other creditors until the administrator can organize orderly and just distribution of available assets to satisfy the company's debts. During this time, the administrator will call a meeting of the company's creditors who are required to submit proof of debt claims. The administrator can continue to operate the company's business if it is considered that the company can trade its way out of its financial problems. This may involve selling some of its assets and entering into a deed of company arrangement with the creditors to accept a percentage of the amount owing and forgo the balance. However, in certain circumstances, companies who are heading to insolvency may choose to liquidate. Liquidation can happen voluntarily, where the shareholders pass a special resolution that the company should be wound up. During this process, they will appoint an accountant to be a liquidator. Or liquidation can happen involuntarily. This happens when the court orders that the company be wound up. Usually, this happens because a creditor applies to the court to have the company wound up. During this time, the creditor must prove to the court the company is insolvent in terms of being unable to pay its debts as and when they are due and payable. Next, liquidation occurs when an external person is appointed as a liquidator to collect and sell off the assets of the insolvent company, distribute the money to the creditors, investigate the conduct of the directors and other company office holders, and if necessary, advise ASIC to charge the directors with criminal offenses under the Companies Act 2001. For example, if the directors are found trading while insolvent. Also, a liquidator is appointed to close or dissolve the company. When liquidation happens, the order of repayment of creditors comes like this, from first as a priority to the fifth, the least priority. So the first person to get the repayment would be the trustee, liquidator fees, and costing of liquidation. Number 2, the secure creditors. Number 3, outstanding employee wages and superannuation, leave entitlements, employee retrenchment pay. Number 4, unsecured creditors. And number 5, shareholders. The third form of insolvency that a company may take is receivership. This happens when a receiver is usually appointed by a secure creditor who has not been paid on time. What happens is this gives the secure creditor the right to take over the particular assets and sell them to pay amounts owed on the loan. A receiver will sell the secure assets of the company to pay the creditor, and the receivership ends when the money owing is repaid. That's the end of the 3 types of insolvency that a company can choose. Next, it is also important to be reminded of the duty of the company director in relationship with insolvency. A director of the company must be aware of the financial health of the company. A director always must consider when the company takes loan or incurs a debt. The director must consider whether they can repay the debt or not. The third, it is very important a director must ensure the company does not trade while insolvent. That's the end of this PowerPoint. Let's recap what is important in this PowerPoint. First is the definition of insolvency. Second, insolvency is defined by Corporations Act and administered by ASIC. Next, it's important to recall the symptoms of insolvency. The third point, it's also very important to know the 3 main forms of insolvency, which is voluntary administration, liquidation, whether it's voluntary or involuntary, and the third, receivership. Lastly but not least, it's important to know the role of directors in terms of when the company is going to be insolvent. That's the end of this PowerPoint. Thank you.